receive it. Our chairs are, I'm sure, already well known to most of you. They're neatly separated at the podium by the lady in red, Wendy Templeton. But on the far side from me is Elena Hoffstein, whom you'll meet in a moment, and closest to me on my left is Brian Schnurr, author of Estate Litigation, co-chair of last year's forum. I won't belabor his many achievements because his CV and those of the other faculty can be found inside the binder. But for the moment, please join me in welcoming Brian Schnurr.
Thank you, Paul. I was hoping you would belabor my many achievements, but I won't. Ladies and gentlemen, my job this morning is very easy. Tomorrow I work, but today Elena works. Let me start by just welcoming you. And as you see from the material, and particularly from the syllabus outline, we've got a wide range of topics across the area of estate and tax planning and estate and mental incapacity litigation. And in designing these 2 days, Elena, I, and our planning committee were trying to put the emphasis on subject areas that weren't covered last year in this forum, and also putting the emphasis on developments, amendments, changes in this area of practice over the last year, and there have been quite a number of those. We have a very full schedule for the 2 days. As you know, today is exclusively estate, trust, tax planning, and issues relating to charities and such things. Tomorrow, we will get into estate and trust litigation, dispute resolution, and mental incompetency issues. We have tried and I think succeeded in scheduling things tightly, but not so tightly that there is not time for questions. And Elena will tell you her approach to questions and what she invites you to do, and I will similarly deal with that tomorrow morning when I introduce day 2. Let's get into day 1. Elena Hoffstein's practice is in the specialized field of estate and tax planning at the Toronto law firm of Fasken Campbell Godfrey. And Elena has made an amazing commitment to continuing legal education. She speaks nonstop, period. She speaks nonstop. But in addition to, and I say that with great affection, but in addition to that, she speaks nonstop and chairs many programs for the Law Society, for the CBA, other organizations, community groups. She's been the head of section for the bar admission course for many, many years. Elena was a teacher before she brilliantly made the decision to go into the practice of law, and therefore she's particularly well suited for the legal education commitment that she's taken on. I can tell you that with Elena's sense of humor and her wide range of knowledge in this area, it's always a pleasure for me to work on programs like this with Elena. So with those words, let me turn you over to Elena Hoffstein, your chair for today, and I will see you bright and early at 9 o'clock tomorrow morning. Elena Hoffstein.
Thank you very much, Brian, for that very kind introduction, and welcome to everybody. I knew he was going to get a jab in. He always does. He's trying to pay me back because a few years ago, I was asked to introduce Brian, and I started reading his CV, and I mentioned how he was born in the 1920s, and he went to school at U of T, and he's waving madly at me and shaking his head, and I got so far as to say that he plays the bagpipes walking up and down on his driveway when I suddenly realized I was reading Rodney Hull's CV. And he hasn't quite forgiven me for that. So he doesn't let me make intros anymore. Anyway, I wanted to repeat my welcome, the welcome that Brian has extended to all of you. I'm delighted to see the numbers that have turned out. And I wanted, before I start the program, to particularly thank Paul Truster, who made the preliminary introductions, and Kathy Stolarczyk, who's out there handing out the materials, for their unbelievable commitment to getting the materials together. As you can tell, the one article that was not in the materials was mine, and that's, you can imagine, that came to Kathy quite late in the day yesterday, and she managed to make all the copies. Now, I'm going to try to allow some time for questions to be asked at the end of each talk. I may not be able to do it with my talk because I decided that I was going to do something a little bit different from the program this morning. Wendy Templeton is here on the podium with me, and Wendy gave a talk on probate planning at this year's Ontario Tax Conference. I gave the talk last year, and she had some very interesting observations to make, and I thought it would be of interest to all of you if I curtailed my time a bit and gave her an opportunity to share some of her thoughts and the creative probate planning ideas that she had with you this morning. And the Canadian Tax Foundation has kindly made her paper available to all of you, and she's made some time available. So I'm going to try and share my time with her this morning. Her paper is not in your materials yet. She is getting Xeroxed off, and so during the course of the day, if you would just check with the front desk, you can pick up a copy of her paper later in the day. Her overheads are in the materials. If you look at tab 1, what you have under tab 1 is a copy of my paper once you insert it, my overheads, which we will be working with, and her overheads. And before I get started, I just want to tell you something about Wendy. Wendy is Senior Manager of Taxation and Estate Planning with the Trust Company of the Bank of Montreal, and she's currently seconded to the Private Client Division of Nesbitt Burns, where she coordinates estate planning services for Nesbitt Burns clients. She was called to the bar in Ontario in 1980, and before joining the Trust Company, she specialized in the areas of tax and estate planning, both in a law firm and in a national chartered accounting firm. She's published in numerous publications, including the Canadian Tax Journal, and has extensive teaching and speaking experience, including the Canadian Tax Foundation, U of T, helping me out at the bar admission course, for which I'm grateful, and the in-depth tax course. So without further ado, I will start. And have you all got the overheads? You found them? Okay, I'll be working with overheads. And I don't know if you can turn the lights down a little. Is that all right? Okay. If this doesn't work, I'm going to have to get some of you who are technically inclined to help me, but let's see what happens. We've had a lot of activity in the probate planning area in the last few years. I know you've all been following it, so I'm not going to spend too much time going over the cases. My paper is much more complete than my talk is going to be. I know that when succession duties and estate taxes were abolished many years ago, a lot of people in the estate planning area started wondering whether they should change their area specialization, and of course now we're all laughing because probate planning has become a brand new vista for a lot of us, and some very creative planning is going on, and certainly bringing a lot of the clients back to the office to do their will planning. The flurry of cases started with the Youdan case, which went, of course, all the way to the Supreme Court of Canada, challenging the constitutionality of probate fees, and the Supreme Court of Canada did agree that the probate fees sure looked like a tax, but that didn't really do away with the problem. Instead, the Supreme Court of Canada said that because it was a tax, the province had not enacted the tax in the appropriate way, and gave Ontario 6 months to clean up its act. And not surprisingly, a few months later, we saw the Estate Administration Tax Act, which basically introduced a probate tax enacted in the right way, and in addition to that, made that tax retroactive back to May of 1950, so that we couldn't go back and claim probate fees as having been improperly charged. The only estate which was exempted from this new probate tax was, of course, the Youdan estate, and that was specifically mentioned in the Tax Act. At the same time, the Granovsky case was percolating through the trial court, and Her Honor Justice Greer upheld the concept of double wills, where one will could be probated, and probate fees, at that time they were called probate fees, could be paid in respect of property passing under that will, but the assets passing under another will, which had much more value, didn't have to have probate fees paid on that. So there was a recognition of this technique of separating out different pots of assets that might or might not need probate and paying probate fees only on the portion covered by what I call the primary will, and what was called in the Granovsky case the primary will, but not shares of private company, which were dealt with in a secondary will. There's been some question as to whether the Estates Administration Tax Act does away with the planning technique of multiple wills, and it was interesting that the Granovsky appeal that the government launched was abandoned after the Tax Act was passed, and led some people to believe that perhaps that signaled the demise of the double will technique. But I understand that the court is still accepting primary and secondary wills. I understand also that the registrar of the court is asking for some sort of undertaking that probate tax will be paid on the assets passing under the secondary will in certain circumstances. I don't know how personal representatives can give that undertaking and still administer and wind up the estate. But some of you may have already gone through that experience and had discussions with the registrar on that. So as we know, probate isn't always necessary. You don't have to get a probated will if you have executors who are prepared to act under a valid will, and the assets passing through death do not require a probated will. Of course, not everyone has that mix of assets that allows you to administer an estate without probate. But again, that's where we come in and assist our clients in arranging their affairs to see if we can get that result, or even if we can't, to minimize the cost of probate by arranging people's affairs to suit their estate planning needs and also reduce probate. And the cost of probate is determined by looking at a number of different things. You look at the Estates Act, and in particular Section 32. You look at the new Estates Administration Tax Act, and you look at the application form. And what that all tells you is that when you're determining the value of the estate for how much tax has to be paid, you don't include in that insurance that's payable to named beneficiaries, assets that are held in joint account, and real estate that's outside of Ontario. You can't subtract debts except for mortgages on real property. And what has happened is that a number of techniques have developed to deal with reducing the cost of the value of the estate. And I've just listed a couple of them. I talked about multiple wills, where you separate out the different pots of assets and then deal with them in different wills. Secondly are inter vivos gifts, either outright or some sort of a halfway house, this joint ownership, where assets could pass these to the surviving joint owners. Inter vivos gifts can either be direct, or there could be through transfers to trusts. Again, the transfer to a trust could be an outright transfer to a trust, or there could be a transfer to a trust of the future growth in value of particular assets. For example, if you're engaging in an estate freeze and the freezor freezes the value of his or her shares, and then the trust for generally other members of the family, children, take the common shares. And so that the future growth value doesn't have to be taken into account in probate planning or probate tax for the transferor freezor. And lastly, designating beneficiaries of life insurance policies, RSPs, RIFs, and the like. And these techniques have given rise to both tax and non-tax concerns, and as well, in the rush to try to avoid paying probate tax and making that a significant focus of estate planning, sometimes people lose sight of the fact that you're missing other opportunities, that maybe the cost of paying the probate tax is less than the opportunity that's missed by not allowing assets to flow through the will. And what I'm going to turn to now is a consideration of both the non-tax concerns as well as some tax issues that arise with some of these techniques, and also just dwell briefly on what opportunities you could be missing by doing probate planning. And just looking first at non-tax concerns, by transferring property inter vivos by way of gift to children, for example, or spouses, you could be exposing those assets to the creditors of the transferees. There could be, these creditors could be business creditors, or they could be spouse creditors under Family Law Act claims. And one of the things that I have discovered is where there's been a premature freeze. A lot of people engage in estate freezing in the late 40s, early 50s, and I'm finding in my practice, and for some reason these things tend to clump together. I've had 3 or 4 clients come to me for tax planning, and I've had the unpleasant task of saying to them, you know, you froze at a certain value, a few $1,000,000, and interestingly enough, the trust that holds the common shares now has a value, the shares have a value of about $20 million. And so it seems to me I should be doing tax planning for your children and seeing how I can protect you in your later years because you froze too early or you gave it away too soon. And it's interesting how many of those persons are starting to come forward now. And of course what happens is that when the children start getting married, we have the problems of trying to encourage them to do marital contracts to protect the assets that really are really the parents, except for the legal reality that they've been transferred to the children. But the parents are still using and enjoying the assets, and I'm sure from the heads that are nodding, there are other people who've had that experience or are having that experience. Secondly, transferring assets to joint ownership or transferring them outright to very often a spouse has the effect of perhaps negating some of the estate planning that's been done. For example, if you've got a complex marriage situation where you've got a spouse of a second marriage and children of a first, and you know, I have a client who very proudly said to me, I don't need to come to you, Ellen, I put everything in joint names. And I said, well, that's great, except that we talked about, you know, a life interest for the spouse so that you could guarantee that the assets go to the children of the first marriage when your spouse dies, so that you've protected both sets of interests, and now you've put everything in joint names, and so therefore your spouse is going to inherit everything and she will have the ability to do what she wants if you die before her. I have other situations where, for example, a parent has put assets in joint names with her children, and then she's got numerous legacies for grandchildren in her will. How do they get paid? So again, the estate plan could be negated by probate tax planning that our clients engage in. And I'm sure you all have many examples, other examples. So that there is a loss of control over who ultimately gets the assets if you engage in some of this probate tax planning. And the other thing is that if you do transfer assets, for example, to the joint names of you and your spouse or you and your children, then you require the consent of the new co-owner of the property to sell the property or to mortgage it and so on. So there's loss of control. Unexpected death out of order is another potential problem. For example, if assets are put in joint names or beneficiaries are designated where there are, say, you're put in joint names with your children, or you designate your children as the beneficiaries of life insurance and so on, and one of the children dies and you're not competent to change the designation or change the joint ownership, then you may find unexpected results that could have been covered off if the asset had gone into the will and been dealt with by provisions that say what happens on the death of one child, the assets would go perhaps to the children of that child. So those are some of the non-tax considerations. Turning now to some of the tax implications of some of this very creative planning. Outright gifts and and transfers of assets to joint ownership give rise to the possibility that unless the transfer is to a spouse, you have a disposition at fair market value. And that gives rise to capital gains in the hands of the transferor potentially, or capital losses, or if you're dealing with depreciable property, could give rise to income and or terminal losses, recapture and terminal losses, so that there may be adverse tax consequences in transferring assets by way of gift or by way of sale. And there could even be double tax problems if, for example, someone is giving away their property but is giving it away by way of sale at more than fair market value. Section 69, and it's a non-arm's length situation. Section 69 would kick in and say that the transferor is deemed to have sold at the price that he asked for, which was more than fair market value, but the buyer will be deemed to have received it at the fair market value, so there's a potential for double tax. If property that is transferred is a principal residence, then the transfer may not result in a capital gain because you've got the principal residence exemption, but you may have the result that the principal residence exemption can no longer be claimed because the person to whom the principal residence has been transferred already had a principal residence and wouldn't be able to claim too. So again, issues that have to be considered when you are thinking about an outright gift or a transfer to joint ownership as a solution to the probate tax. And transfers to joint ownership are very appealing because that's a technique that's simple and elegant. But again, we shouldn't forget that notwithstanding that it is a transfer to joint ownership, it does result in a disposition for tax purposes of, say, if you're transferring to one other person, could result in a disposition of 50% of the property. And then when the joint owner transferor dies, there's a disposition of the remaining 50%. So unless it's a transfer to joint ownership with a spouse, you have to think about the tax implications of even transfers to joint ownership. Transfers to trusts are also difficult and give rise to a lot of tax issues. Now, assets that are put into trust pass to the beneficiaries of the trust and therefore pass outside of the will and outside of the probate process. But transfers to trusts may trigger capital gain considerations and also may attract the attribution rules. So generally speaking, a transfer to a trust is treated as a disposition at fair market value. And the question arises as to whether there are any possible transfers to trusts where probate tax can be avoided and you don't have a disposition at fair market value. And I contrast transfers to trusts to transfers to corporations where the Income Tax Act does allow for a tax-free rollover of assets to a corporation pursuant to the provisions of sections like Section 85 and Section 86. You don't have that for trusts. But if you look at page 11 of the materials, there's 3 different types of trusts that Revenue Canada has expressed a view on as to whether they are dispositions or not dispositions. And those are revocable living trusts, protective trusts, and bear trusts. And I'll just go through them briefly. What's a revocable living trust? At the bottom of page 11, top of page 12, a revocable living trust is described as one where the settlor is the only beneficiary of the income in the capital. And if you would just add to that, there's some typos and left out here, during his or her lifetime. And number 2 is the trustee. 3, retains the power to revoke, alter, or amend the terms of the trust and has essentially the ability to deal with the trust assets at all times. And then I would add a 5th one, that other beneficiaries have rights on the death of the settlor if he doesn't revoke the trust before that. Now, Revenue Canada used to take the position that a transfer to a revocable trust would result in a disposition only of the remainder interest, but they've changed their mind in the last few years and have confirmed their new position in the December 23, 1998 draft legislation, the explanatory notes, where they now say that a transfer to a revocable living trust is a disposition of the entire value of the property being transferred, and it's a disposition at fair market value. The second type of trust they look at is a protective trust, which I describe on page 13 of my paper. And this is one where the settlor is the only beneficiary of the trust. is entitled to as much of the income and realized gains as they request. The property reverts to the settlor if the trust is terminated before the settlor's death, and will terminate in any event on the death of the settlor unless earlier terminated. And when the settlor dies, the property that's in the trust devolves in accordance with the terms of the settlor's will or the intestate laws that apply. Now, what Revenue Canada has said is transfers to trusts that qualify as protective trusts will be dispositions, but they will be qualifying dispositions, which means that there will be no tax consequence, and there will be a rollover if there is a transfer to a protective trust. And I go through the reasons for that in my paper, so I apologize for not going through it in detail here, but that's the result of the discussion. And the last one is bear trusts. And a transfer to a bear trust is one where there are no significant powers or responsibilities given to the trustee, and the trustee can take no action without instructions from the settlor. Okay, so it's the situation we're commonly used to, where there's a transfer of legal title but not a transfer of beneficial ownership. And so in transfers to bear trusts do not trigger a disposition for tax purposes, and you can use the bear trust for a probate planning if, for example, all of the assets that a person has could be put into the name of a bear trustee, so that you don't have to probate at all to deal with any of the assets. That's a technique that can be used and has been used to avoid having to obtain probate. And you can also consider combining the technique of putting assets into a bear trustee, very often using a corporation, bear trustee corporation name, combined with primary and secondary will techniques to avoid having to obtain probate for certain assets. Then we have the qualifying spouse trust, where there is a rollover for tax purposes if there is a transfer to a trust for a spouse, for the benefit of a spouse. But of course, once the asset is in there, you run the risk that the spouse may die before the transferor dies. So that's a technique that I've used in a couple of occasions where I've had a situation the person's close to dying. The will provides for transfers to testamentary spouse trusts, and we have dealt with the probate tax issue by transferring to a spouse trust, but there we knew that death was imminent and it made some sense. And lastly, transfers to trust where you're transferring principal residence, whether it's the place in the city or the place in the country, and you get the principal residence exemption on the transfer into the trust, but of course you run the risk of losing the principal residence exemption while for some beneficiaries while the property is in the trust. So you have to consider that. And again, my paper goes into more detail on that. Okay, some of the other tax implications are the attribution rules. When there are transfers either outright or to trust, you have to, and it's in an arm's length situation, you have to worry about whether the attribution rules will apply, even if the transfer is done on a tax-free basis, for example, to a spouse. There will be an attribution back to the transferor of any income or capital gains generated from the transferred property. And so those rules apply if there are transfers of property or loans of property to a surviving spouse or related minors and nieces and nephews. And those are the personal attribution rules. There are also, if you are engaging in estate planning involving corporations and you're doing a freeze and there's a transfer of the future growth, you have to worry about the corporate attribution rules in 74.4 sub 4 of the Income Tax Act, which is considered in my paper, but something you have to be aware of, and aware of how you get around the potential application of the corporate attribution rules by structuring your trusts in the manner that's described in the paper. Now, the Newman case and Section 56 sub 2, which provides that a payment or transfer with the concurrence of or at the direction of a taxpayer for the benefit of another person who's related could have the effect of triggering an attribution rule. The Newman case in the Supreme Court of Canada said that if corporations, directors declare discretionary dividends to different classes of shares in a disproportionate manner, that's allowable. And the feeling was that, that Revenue Canada would not sit on that decision, but would come out with some legislation to deal with it. And sure enough, we have seen the introduction of what I call the kiddie tax in the latest federal budget and in the September 10th, I think it's September 10th draft legislation, where in effect dividends that are received by a minor person from shares of a private corporation, and again, you can think about that, how that might happen in the context of an estate freeze, the child who receives that dividend will be paying tax at the top marginal rates. So the response, the government response seems to be, well, we'll just tax the recipient of the money and forget about trying to create other traps, and we'll just go directly to the recipient of the funds and tax that person. So it's not an attribution rule, but a direct tax on the child. And on page 24, I go through some of the exceptions to this new kiddie tax. Basically, if the income is received from publicly traded shares, then that tax isn't going to apply. If the shares in question, even if they're private company shares, if they're inherited by the minor person from his or her parents, now I don't know why they stopped at parents. What happens if the shares are inherited from grandparents? That doesn't seem to be within the exception. Another exception is if there is income on other inherited property in any year during which the minor is in full-time attendance at a post-secondary educational institution. I found that an interesting exception because how many 17-year-olds or younger than 17 are at university? So you have to be thinking about a genius. That was going to be a fairly restricted exception. And the last one, which was also a little intriguing, was the kiddie tax won't apply to minors who have no parents resident in Canada at any time during the year. Well, how many minors do you know whose parents don't live with them? So anyway, I found all of those very intriguing. And the last attribution rule you have to think about, which is probably the most insidious, is Section 75 sub 2, which says that if the transferor transfers assets to a trust and either the assets can revert to the transferor or the transferor retains some sort of control over where the assets ultimately go, then the income and capital gains generated by that property in the trust will be taxable will be attributed back to the transferor. And this provision is insidious not only because of what it says in it of itself, but because it triggers the application of another section, 107.4.1, which says that while the usual rule is that assets that go from a trust to a beneficiary in satisfaction of that beneficiary's capital interest would roll out of the trust with no tax effect, if 75.2 applied to any property of the trust at any time during the history of the trust, then there will not be that rollover available. So a very interesting section. In my paper, I go through a number of ways in which you can get caught by 75.2. Revenue Canada has come out with a lot of comments about the fact that if a transferor of property is the sole trustee, or one of two trustees, or one of three or more trustees, but retains the right to form part of the majority, that will trigger 75.2. Very quickly going through one last issue on creative probate planning is a question of who will bear the tax burden on some of these creative probate plans. And I talk particularly about beneficiary designations and jointly owned property, where the recipient, the beneficiary of the RSP, for example, will receive the asset free of tax, and the tax will, and the joint owner will receive the property free, outside of the will, but the estate will be stuck with the responsibility for paying the tax. And if you have one child getting the RSP or a jointly owned property, another child getting the residue of the estate, it could create an inequitable situation. And I'm just leaving that because I know Wendy's going to elaborate on that in a few minutes. And go to my last point, which is by doing creative probate planning and transferring assets outside of the will, you may be missing opportunities to do better tax planning for your clients. All of us are aware of the executor's year, where you can split income for at least 1 year or during the initial administration of the estate, and you can have the testamentary trust, which is created when the estate springs up, enjoy the low marginal rates. You can multiply the marginal rates of testamentary trusts by having multiple testamentary trusts set up in a will. If you leave assets outright, you lose that opportunity. And I give an example in the paper of someone who, for example, receives $1 million of life insurance outside of the will. So you save probate tax of $14,500, but had that insurance gone into, say, a spousal trust, and there had been a sharing of the tax rates, there could have been a tax saving of at least $10,000, and that's in year 1, and then you have that benefit continue on over the years. So query whether you ended up being a winner for your client by avoiding the one-time probate tax and losing the other benefits. And the last point I want to make before I turn this over to Wendy, who's been so patient, is that the opportunities for charitable giving and the tax benefits of having 100% tax credit in the year of death will only work if, for example, you make the gift to charity not outside of the will but through your will. And there is a provision in the Act that says that any gift given to charity in a will is deemed to have been given in the year of death. All right? So if you have $1 million of life insurance and you have it go into the estate, sure, you pay $14,500 of probate tax, but you could have enormous tax benefits by making the charity credit available to you. There are some issues which I go through in my paper about charitable gifts that are given on the termination of a life interest, and how you've got to arrange the life interest in such a way as to make it available in the year of death, and some disturbing commentary from Revenue Canada where they say that if the testator gives the choice of the trust, of the charity, or the amounts to be given to charity, if he gives that flexibility to the trustees, they will take the position that that's not a gift given by will, but rather a gift given because the trustees have participated in that decision. So again, how you structure your will, what you put in it, if you want to take advantage of the charity credit, will be very important. So thank you very much. I'm just going to turn this over to Wendy.
There, can you all hear me? As Elena has stated, my paper will be available for, it is being photocopied probably as we speak, and it will be available for you at, I think at the lunchtime break. What you have essentially in your handout materials now is a selection of the overheads from a part of the paper. The paper that I did was really entitled A Potpourri of Estate Planning Issues, Tips and Traps. And essentially what I was experiencing in reviewing so many people's estate planning, clients of Nesbitt Burns and the trust company, was seeing so many issues arising from dangerous self-help in the probate fee planning area. And so my paper really sprung from a lot of those issues. And what I'm going to focus on today is a limited part of that paper, which looks at the RRSP designations. We're really seeing RRSPs becoming a larger and larger part of people's estates these days, with the changes in the annual limits for contributions and the period of time during which people have had assets in their RRSPs, perhaps have transferred assets from pension plans. It's really become a very large part of the estate. And so RSP designations have become very important. And there's two essential rules with respect to RSP designations and the taxation of RSPs, which I go into in my paper and which the following slides kind of assume that we've already discussed. And that is that essentially, on death, the proceeds of an RSP or a RIF, a registered plan, are taxable to the estate. That's the basic rule. And even where the named beneficiary, say, is a spouse or another person who qualifies for a rollover under the Income Tax Act, the basic rule is still that the estate is taxed on those proceeds, and then the executor has an option to allocate the proceeds to be taxable to a qualified beneficiary. So we may assume, for example, and I think typically we always assume, that where the spouse is a designated beneficiary, there will be a rollover. But this is not the case. The executor of the estate must actually make the deduction in the terminal return in order for the spouse to be taxable on those proceeds and in order for the spouse to be eligible to roll them to his or her RSP. I guess the second thing that in looking at this issue that I became painfully aware of is that there's an option here. This option provides some planning opportunities that people have perhaps previously not been made aware of, and that these planning opportunities are ripe with potentials for conflict amongst executors and beneficiaries. So just starting with the first slide, when should the designation be in the will? This really refers to where the physical designation is. So if you put the designation in the will, the real advantage is that often when a client comes in to give will instructions, they may tell you that they have designated a beneficiary, but that may or may not actually be correct. And if you're in the position of having a client who is not sure, and there are many situations in which a valid designation could be made, but then it may no longer be valid. For example, if the fund plans have been transferred, the plan has matured and transferred into a RIF, the original designation may no longer be valid. So you may want to actually physically put the designation in the will. And there you're in the position of, well, if I put the designation in the will, do I now make the proceeds subject to probate? And many practitioners put the designation in at the beginning of the will before the trustees are charged with holding the assets of the estate in trust, in the hopes that that designation will be treated as not part of the estate and therefore not subject to the estate administration tax. And that can be very effective. However, the Trust Companies Association has a protocol that if the designation is in the will and the value of the registered plan exceeds $30,000, they will require probate. So what you might want to do in case that becomes a problem, and I've seen this, and I think it's a good practice, is where you're not sure, and so you would like to put the designation in the will just to make sure that it goes to the right beneficiary, then you can put it in the will, but you can make it valid only if there is not an otherwise valid designation in favor of that particular beneficiary. And then you've kind of got the best of both worlds, because if there's a valid designation on file with the financial institution that's consistent with that in the will, then you don't need to rely on the designation in the will. And if there isn't one, then you've got the designation in the will and you possibly have the argument that estate administration tax is not payable. Now, there are times when you just don't have an option and you must make the beneficiary the estate. And I find that because of estate administration tax or probate fee planning, that there is such a compulsion to name a beneficiary. There's in a designation rather than naming the estate. And there's also a misconception that the rollover treatment of registered plans is not available if you name the estate. And that's actually also not true, because what happens is that the executor or the legal representative can make an election if the person who is a beneficiary of the estate would otherwise qualify for the rollover. The executor can make an election to allocate part of the interest in the estate to that beneficiary as coming from the registered plan. And that will enable the qualified beneficiary to take advantage of the rollover. The difference between having it in the estate and doing it that way and having the person receive the proceeds of the registered plan by virtue of a designation is that the beneficiary has to consent. if the registered plan proceeds go through the estate. But otherwise, the tax treatment is identical. You're going to be kind of stuck with making the estate the beneficiary where you want to impose trust provisions. So for example, if the beneficiary is a minor, Revenue Canada does permit a trust for a minor to purchase an annuity to age 18 and defer the tax proceeds of a registered plan. And that can be done through a trust that's in the will. And you're probably not going to be able to avoid the estate administration tax in that situation. There are other situations where you're not really going to be able to avoid making the estate a beneficiary, and that's where the assets of the registered plan form a very large portion of the estate. Say where there's a lot of jointly held property, or you have large debts in the estate, or there's going to be a significant tax liability. In order to properly divide the assets of the estate amongst the beneficiaries, it may just have to go through the will, or you're just not going to be able to divide the estate up in the manner in which the testator really wants. Where the designations would be complex, where you have, say, a number of contingencies relating to the beneficiaries of the registered plan, you may really just have to do that through the will, because you can't get too fancy with designations. If you want to give the registered plan proceeds to charity, you must make the estate the beneficiary. Revenue Canada takes the position that if you name a charity as the beneficiary of the registered plan, that you don't get the charitable credit, and the estate would still be taxable on the full proceeds of the plan. So that would be a pretty major problem. The way to do that is to name the estate as the beneficiary of the plan, and then in the will you name the charity either as the benefit of the net proceeds, or just name the charity as the beneficiary of the gross proceeds, depending on what the testator intends. I mentioned that you can't get too fancy with the designations, and generally the designation of registered plan beneficiaries, the legislation is contained in the Succession Law Reform Act. It actually authorizes designations for registered plans, and it talks about a person being designated. Essentially, it doesn't talk about contingencies, and so generally what we will accept is where you name a number of beneficiaries equally. We will not accept, for example, where there are different portions to different named beneficiaries. So if you want to name, say, your 3 children, you name them equally, or they're survivors. And Elena has mentioned there could be a problem if you're not specific as to what happens if one of the named beneficiaries, if you have multiple named beneficiaries, dies before the annuitant of the plan. What happens? Does that person's share go back into the estate of the annuitant, or does it get distributed equally to the other co-owners? That could create a problem, and it could be resolved by a very careful drafting of the designation. The problem is these designations are often done when an RRSP is opened. They're often done on a financial institution form, which doesn't really provide many options, and you may not have a whole lot of control over it. What isn't acceptable, for example, is a 30-day survival clause, dividing up into different shares, or say a certain amount to X and the remainder to Y. One solution where you want to have multiple beneficiaries and you want to avoid this naming 3 people on one plan, one solution might be to sever the plans, say, into 3 parts, and name each child as the beneficiary of each plan. Now, it doesn't make a whole lot of sense from an investment point of view, but at least it would make it clear what happens if one dies before the annuitant, because what would happen is then most plans provide, if there's not a valid designation, it simply goes back into the estate. And you could even sever parts of the plan so that some goes to the estate and some goes to the beneficiary outside the estate, and at least you maybe have reduced the estate administration tax. And what you can do in the will is create a hodgepodge And wherever a registered plan or other assets are passing outside the estate, I think it's a very, very good practice to always include a hotspot clause in the will, so that in the event that you do have this unequal distribution of wealth as a result of assets passing outside the estate, that at least what does pass through the estate can be used to equalize the various interests of the beneficiaries, so that the testator's overall estate gets distributed in a manner that's consistent with his or her intentions. And we don't very commonly see hotspot clauses in wills, but I think that it should maybe become a more common practice, particularly where you see large amounts passing outside. I want to just talk about the option that the executor has with respect to allocating the taxation of the proceeds to a qualified beneficiary. And go into this quite a bit actually in my paper, and also talk not only about the option, but also about the ability for the beneficiaries to waive their rights under the registered plan designation and for it to go back into the estate. And the combination of this option that the executor has with respect to the tax treatment and Revenue Canada's recognition that there can be a waiver provides some very interesting planning opportunities and some very interesting issues of conflict for an executor to resolve. So just looking at one example, supposing we have a situation where it's a second marriage and the assets of the estate are going into a spousal trust, and the residual beneficiaries are the children of the first marriage, and not an untypical situation. And let's assume for the sake of argument that there's a domestic contract that excludes any right, any claim of the two spouses under the Family Law Act. And we have a large RSP that the wife, Marion, is named as the beneficiary. And I put some actual numbers in the paper. But let's supposing then that the Peter, who has this large RSP, dies, and Marion receives the proceeds of the RSP, and they're always received without withholding tax, so she receives the gross proceeds, and then the balance of the estate is to be held in trust for her during her lifetime. Let's assume that she is the executor of the estate, and she chooses not to make the deduction. So in other words, the RSP proceeds are going to be taxable to the estate, even though the surviving spouse has received them. She says, well, I'd really just rather have the cash because everything else is held in trust, and I don't really want to put it into my RSP. I don't need the deferral, thank you very much. Let the trust pay, let the estate pay the tax on the RSP. So less goes into the spousal trust, and ultimately less will be distributed to the children because the estate is going to pay the tax. Now, presumably the children are not going to be pleased with this sort of an arrangement. And I guess the question would arise as to what is the obligation of the trustee here. You're really almost into a situation where you're thinking about the even-handed rule. And, is there an obligation to take the deferral and allocate the proceeds to be taxable to the spouse so that the spouse really has no choice other than to pay the tax but to put it into their own plan? Or is it really, can the executor have a complete freedom? And typically in a will you see very typically you see the clause that gives the election to the right to the executors to make elections under the Income Tax Act, but I've never seen a direction with respect to a surviving spouse and whether or not the intention of the testator is that the trust should pay the tax or the proceeds should be taxable to the spouse who should then use a rollover. I commend the rest of my paper to you, and thank you very much.
Thank you very much, Wendy. I'm sorry I had to curtail Wendy's talk, and I really do agree with her. I think her paper is well worth reading. There's some very helpful hints for us all. I'd like to now turn to Jennifer Pfuetzner. Our next speaker. I'm just going to try and close this off so Jennifer's not bothered by this. I'll take my technical guru here. Jennifer works with Davies, Ward & Beck. She was called to the bar in 1995 and became a partner of the firm in 1998. She received her Bachelor of Arts in Science from McMaster University in 1990 before going to law school. Jennifer practices primarily in the tax, trusts, and estates area and has lectured for the Law Society on trusts and estates and has been an instructor at the Bar Admission course. And she's also a lecturer in trusts at Osgoode Hall Law School. So Jennifer is going to talk to us this morning about powers of attorney and some of the emerging issues. And I'm sure we're going to see a lot more of problems in this area.
Just have to get my mic working here. Good morning. There's three areas that I want to talk about today, and they're all three covered in my paper as well. Dealing with the management of property under continuing powers of attorney under the Substitute Decisions Act, which I will refer to, as we all do, as the SDA for short. The first topic is, what are the limits on the attorney's power? The second topic is issues that arise when you're advising third parties dealing with attorneys. And the third topic is powers of attorney for property in commercial contexts. So the first topic that I'm going to turn to is, what are the limits on the attorney's power? And the general proposition under the SDA is that an attorney under a continuing power of attorney can do anything in respect of property that the grantor could do if capable, except make a will. So it seems to give a very, very broad power, virtually identical to what the person could do if capable, other than making a will. This is subject to a few things in the SDA. The first being the fact that the attorney is a fiduciary. This is also the position at common law, but it's been specifically provided in the SDA that this is the case. So the attorney has to act in good faith for the incapable person's benefit. The SDA also sets out certain required expenditures that have to be made from the person's property. This is in subsection 37(1). They include payments for the support, education, and care of the incapable person and his or her dependents. So those have to be made. The SDA also outlines optional expenditures that can be made from the person's property, which include gifts or loans to friends and relatives, and also charitable gifts. And there are rules that these kind of gifts are subject to, so they can't just be made in the attorney's discretion. The rules are set out in subsection 37(4). The first rule is that the property remaining has to be sufficient for the care of the incapable person and his or her dependents. The second rule is that the gifts and loans to relatives and friends can only be made if there's reason to believe, based on the incapable person's intentions expressed while capable, that they would have made the gifts. So it has to be consistent with intention expressed by the incapable person before they became incapable. With respect to charitable gifts, these can only be made if the power of attorney authorizes them, or if the incapable person made similar gifts while they were capable. If a power of attorney contains instructions regarding gifts or loans or charitable gifts, then the instructions are to be followed, but they're subject to the following 2 points. The first point is that wishes expressed by the incapable person will override the instructions in the power of attorney. And the second point is that charitable gifts are limited to 20% of the income of the property in the year, regardless of what is provided in the power of attorney. And I think that is quite a noteworthy point, because you cannot contract out of the SDA. The power of attorney is always going to be subject to it. So regardless of what the person has in their power of attorney regarding charitable gifts, the amounts are limited to that 20% amount. There is an ability for the court to authorize charitable gifts in excess of that 20% limitation, but it involves obviously a court application. The next question is whether an attorney can anticipate the provisions of a person's will. That is, can they make gifts to the people that are the expected beneficiaries under the will? The SDA requires the attorney to determine whether there is a will, and if there is, to determine its provisions. And the SDA also specifically provides that a gift can be made to a beneficiary under the will if the gift is otherwise authorized under Section 37, and those are the points that we just looked at. I would note that these provisions don't seem to apply to intestate successors. So if you have an incapable person that doesn't have a will and you want to make gifts to their intestate successors, these provisions in the SDA may not apply. The next question is whether the attorney can make a gift to him or herself. The first point to remember is that the attorney is a fiduciary. So the first sort of main idea is that any unauthorized use or any personal use of the incapable person's property could be in breach of that fiduciary duty. On the other hand, it's extremely common for people to appoint their spouse or dependent child to be their attorney, and often for the exact purpose that if they become incapable, they want that person to be able to access their funds for their own support. So query whether that creates some kind of implied authorization that the attorney can use the incapable person's property in that kind of a situation. Also recall that the SDA requires the attorney to make payments for the support of the person's dependents. So if the attorney is him or herself a dependent, then it's arguable that those kind of payments are actually not only authorized but required under the SDA. But at the same time, that provision that deals with payments to dependents doesn't specifically contemplate the attorney actually being one of the dependents. So it's not, I think, 100% clear that it would apply in that situation. And the bottom line, I think, because of the uncertainty, is that if it's going to be a large amount that is going to be used, or there's any kind of issue as to the proprietariness of doing it, a court application should be made for authorization. And similar considerations would apply if the attorney were a friend or relative of the incapable person and wanting to make a gift or loan to him or herself. The other point I would make is that if you're drafting a power of attorney where a spouse or other dependent is being appointed and you know that the person intends them to be able to use the property for themselves, then a specific clause should be put in the power of attorney authorizing those kind of payments so that this issue won't arise. The next question I'm going to talk about is, what are the investment powers of an attorney under a continuing power of attorney? In the SDA, there's no specific standard for investments provided, unlike the Trustee Act, which provides a standard for trustees. And the SDA, in fact, says that the Trustee Act does not apply to attorneys. So in making investments, the general standard of care under the SDA will apply to the actions of the attorney. And that standard is where the attorney does not receive compensation. The standard is that of a person of ordinary prudence. A different standard is provided for attorneys that do receive compensation, and that is the standard of a person who is in the business of managing the property of others. The next question that I'd like to talk about is, can an attorney make decisions which affect the personal status of the incapable person? And there's been a few cases in Canada on this, two of which are cited in my paper dealing with actions or petitions for divorce. And both cases have determined that a person appointed as either committee of a person's property or an attorney under a power of attorney for property cannot make decisions or take steps which affect personal status. So they cannot bring proceedings for divorce or continue a petition for divorce started by the incapable person. On the other hand, in Ontario, it's been decided that attorneys for property do have the power to make an election under the Family Law Act for an equalization of net family property. It was decided that that is not an election that is a personal election. It is considered personal only in the sense that the benefit of the equalization payment has to be for the incapable person. It can't be for others, such as creditors or the estate of the person. Sort of related to this topic is there an ability for the attorney to make personal acts that would otherwise normally be required to be done by the principal? And what I mean by that are things like, if the principal is a trustee or a director of a company or has some kind of fiduciary position, can the attorney exercise those fiduciary powers on the principal's behalf? And the answer to that, I believe, is no, that those are the kind of things that cannot be done by an attorney. And there's a case that's cited in my paper from the United Kingdom, Klaus versus Peer, that dealt with whether an attorney could swear an affidavit on behalf of the principal, and it was concluded in that case that they couldn't. And a general principle was established that an attorney cannot do an act required by the principal that arises out of a duty that's of a personal nature, requiring some kind of skill or discretion for its exercise. And I think that principle would clearly apply to the exercise of fiduciary powers. The next topic that I'd like to turn to, and I think this is perhaps the most interesting one and very current, is the extent to which an attorney can engage in estate planning or probate planning on behalf of the incapable person. And as many of you are aware, there's been 3 cases recently in British Columbia that have dealt with applications on behalf by committees in British Columbia to engage in estate planning. Before I turn to those cases, I'd just like to discuss briefly the leading case in this area from the United Kingdom, which is called Re L. And it's a 1965 case from the English Court of Protection. In that case, the incapable person was a bachelor, age 68, no children, was confined in a mental hospital. He had been incompetent since the age of 17. He had assets, fairly substantial assets of £130,000 at the time. This was in the mid-60s, almost all derived from relatives who had died intestate. And he was in a public hospital, so his care was paid for. And the entire cost of his care per year was about £200. So he had way more money than he was ever going to need. A proposal was brought before the court to basically settle and gift almost all of his property to relatives and to a family employee who had cared for him for years, and leaving the incapable person with about £17,000. And the reason for doing this was primarily to assist the relatives, but as well to avoid the death duties that would result on the incapable person's death, which were levied at the rate of about 50% of the value of the estate. And Justice Cross reviewed the proposal, and in reviewing it established the principle that when reviewing such a proposal, the court should try to put itself in the shoes of the incapable person and to view the proposal as the incapable person would do if they became capable for a short period, knowing that they would again lose capacity and being aware of all of the circumstances, and then basically consider, would I make this gift or settlement if I knew these facts and knew that I would not be able to make a will, that I would again soon be incapable. And in this case, the court concluded that being apprised of all the facts, the patient would make a substantial settlement of a large amount of his assets and approved the plan with slight modifications. The first case out of BC is the Reed-Goodman case. In that case, it was essentially a proposal to transfer 2 pieces of real estate to the adult children of the incompetent person, one of whom was the committee who had brought the application. There was no financial need on the part of these adult children. They didn't actually need these properties transferred to them for their support. In fact, they were already using them. There was also no independent evidence of the incapable person's wishes in this regard. The committee said he believed that his mother would have wanted to do this, but that was as far as he could really say. And also there was no evidence that there would be any substantial tax savings from the transfers. In fact, there was evidence that the transfers would trigger capital gains. The public trustee took part in the proceedings and argued that the BC statute, which is very similar to the Ontario statute in terms of the powers that are given to the committee. The public trustee argued that the BC statute required the incapable person's assets to be preserved unless a clear case of necessity can be made out as to why the assets should be distributed or changed in their nature. And the court seemed to accept this argument. However, I would submit that the case, I believe, failed primarily because the applicant did not make out a very good case as to why these transfers were necessary or even desirable. They were clearly not for the incapable person's benefit, and there didn't seem to be any other factors that would compel the court to approve it. The second BC case is called Bradley, and this is the case that adopted the reasoning in L very closely. That was the first UK case that I talked about. In Bradley, the incapable person was a longtime resident of Canada, but a US citizen who had an estate worth about $2.6 million. There was clearly a concern that US estate tax would be payable on her death. And the husband of the person had been appointed her committee and brought an application to make substantial gifts to her sons and to the husband in order to reduce her estate to avoid US estate tax on her death. There was evidence that the patient, prior to becoming incompetent, had sought US tax advice but had been unable to actually take any planning steps before she became incompetent. And there was also evidence that she had previously made large gifts to her sons. The public trustee of British Columbia, again, in that case, argued that the assets of the incapable person cannot be changed except in cases of necessity. And the judge in this case rejected those submissions and said that there were cases in BC that had held that previously, but they were under earlier legislation before their legislation had been reformed to give committees the extremely broad powers that they have that are similar to the SDA. And the court also adopted the reasoning from the L case and said that they believe that the incapable person would have made these gifts if she were capable in knowing all of the facts. So the proposal was approved. The third case from BC is O'Hagan versus O'Hagan. The incapable person in this case was an 89-year-old man with severe Alzheimer's. He had assets worth about $7.2 million, most of which were shares in a private company that had accrued capital gains. And there was a concern about how the inevitable capital gains tax would be paid on his death, and a realization that a large dividend would have to be paid from the company in order to pay the tax, that assets would have to be sold by the company, and there was going to be a lot of tax payable. In order to avoid as much of this tax as possible, the committee of the man brought a proposal to the court that involved an estate freeze and corporate reorganization in order to try to limit this tax. The court reviewed the case law, including Re L and the Re Bradley case, and concluded that the court would, in the right circumstances, approve gifts of property in order to avoid tax. However, the court refused to approve this proposal on the basis that it went beyond anything that had been previously approved by the court in BC or elsewhere, and that it was too much of a radical, complex change for the court to give its approval to. I would submit that the court perhaps didn't fully understand the nature of the proposal in this case, and I would argue that the corporate reorganization that was proposed here did not in fact make a radical change to the assets of the incompetent person, as was done in the Re Bradley case, where approval was given to making large gifts. The net value of Mr. O'Hagan's estate was not going to be reduced substantially, whereas in Re Bradley, that was in fact the whole purpose of the proposal. However, the Re Bradley proposal had the advantage of being very simple and sort of elegant in its simplicity. I'm going to turn now from the issue of what powers an attorney has to the next topic, which is advising third parties in dealing with attorneys and principals. Certain third parties, such as banks and brokerage firms, are very frequently faced with unique issues in dealing with powers of attorney and their principals. A third party acting in good faith on the advice provided to them or the instructions provided to them by an attorney will be protected from liability. At common law, they can rely on the attorney's warranty of authority. So unless they have reason to believe that there's something that's not right about the attorney's authority, they can rely on that. Under the SDA as well, the acts of an attorney done after a power has become invalid will bind the principal and the third party, as long as the third party has acted in good faith and weren't aware of the invalidity. However, third parties who come to you for advice are not going to want to rely on these sort of things after the fact when something has gone wrong. So they're going to want practical advice to deal with common situations. The first situation that I'd like to talk about is just the sort of standard case where the third party is approached by the first time by the attorney saying, you know, your client, my grandmother or whomever, has given me this power of attorney and she's now incompetent, so I'm going to be giving you instructions from now on. So the third party might say, well, I just want to make sure that this is okay, that, you know, this is genuine. So what they could do in that situation, just from a practical point of view, is contact the principal. Just write them a letter confirming that this is a situation, that they've appointed their grandchild as attorney and that they are now going to be taking instructions from them. And generally speaking, if there is something wrong in the situation, if the attorney is fraudulent, a letter like that will bring that information out before something goes wrong. The second case, and this one is, I think, much more difficult, is where a third party receives contradictory instructions from the principal and from the attorney. And it's usually accompanied by the attorney telling the third party that the principal has lost capacity and that they shouldn't accept their instructions anymore. If the third party follows the attorney's instructions and not the principal's, they obviously risk liability of disobeying valid instructions of the principal if it turns out that the principal does have capacity. But on the other hand, if they decide to follow the principal's instructions, they risk liability if it turns out that the principal didn't have capacity and then they've followed instructions that were not valid because the person didn't have capacity to give them. And the Substitute Decisions Act does not protect the attorney in this situation. And I don't believe anything at common law does either, because they've been put on notice as to the situation. So I think what the third party should do from a practical point of view is try to get medical evidence as to the principal's capacity. If they can't get any satisfactory evidence, they're going to have to basically freeze the assets and not take any steps until there's been some kind of court determination. If the medical evidence that they receive and they act on turns out to be incorrect, they're probably not protected either. However, I think it's unlikely that that's going to happen, that they're going to act on medical evidence that turns out not to be correct, but it's possible. And the last topic that I just want to briefly discuss is powers of attorney in commercial context. And the type of power of attorney that I'm talking about here, or thinking about here, is the common law power of attorney called a power coupled with an interest. And this is the type of power that is given as security typically. And the example that I give in my paper is a situation where shares have been pledged as security for some kind of debt, and a power of attorney to transfer the shares in the event of default is also given along with the shares. Now, in order to protect the security of the creditor, the power of attorney will have to be irrevocable, and it will also have to survive the death or incapacity of the grantor. At common law, powers of attorney were revocable by the grantor at will. They were revoked on the grantor's incapacity and revoked on the grantor's death. Exceptions were provided, however, for powers coupled with an interest on the basis that in order to preserve the person's security, they had to be irrevocable. And this exception was also provided for powers of attorney that were given for valuable consideration. Under the Substitute Decisions Act, however, Section 12 of the Act provides that all continuing powers of attorney will be terminated when the grantor dies or when revoked by the grantor. And as I mentioned before, there's no ability to sort of contract yourself out of the SDA. So if you have a power of attorney that is considered to be a continuing power, it is subject to these termination provisions in the SDA. And the only thing that you need in order to find yourself with a continuing power is a statement in the power that it's meant to continue through the grantor's incapacity. So the question then arises whether Section 12 of the SDA applies to powers coupled with an interest. And if it does, obviously that could seriously undermine commercial transactions that rely on these types of instruments. One way to deal with that is to make sure that you don't have a continuing power by not putting anything in the power that specifies that it's to continue through incapacity. I think that's probably unnecessary. There's no indication whatsoever that when the SDA was drafted or when the previous provisions of the Powers of Attorney Act were drafted that anyone took into account powers of attorney coupled with an interest. And I don't believe that there was any intention that these provisions actually apply to those kinds of powers of attorney. And I would find it hard to believe that a court would apply the Section 12 provisions to such a power. And that is the end of my time. Thanks.
Thank you very much, Jennifer. I think one of the beauties of chairing a conference is that you have the ability to select topics that you always wanted to know the answers to and get other people to talk about them and do all the work. That's right. So thank you very much. That was wonderful. I always had a question about powers of attorney coupled with an interest, so there you go. Our next speaker is Terry Carter, who is well known to many of you. Terry practices in the area of, there he is. Terry practices in the area of charities, not-for-profit organizations, trademarks, and fundraising, and has particular experience involving religious organizations. He's with the Orangeville firm of Wardlaw, Mullen, Carter, Thwaites, and Ward, and he's also a registered trademark agent. He is the current chair of the Charity and Not-for-Profit Law section of the Canadian Bar Association and an executive member of the National Charity and Not-for-Profit section of the Canadian Bar Association, and has membership on Government Relations Committee of the Canadian Association of Gift Planners. He is a frequent speaker and published articles in this area, and I can tell you from personal experience that he is a terrific person to consult with. He's always very free to give his time when we have problems, and I personally appreciate that. I also want to tell you that Terry never ceases to astonish me. I took a look at the length of his paper, and this is not uncommon with Terry, and I can now understand why I was getting frantic phone calls from him during the course of the last few weeks saying, Elena, I'm not sure why I agreed to take this on. Because this thing is getting a life of its own, and I can now understand what he was saying. Terry, I think the challenge will be, how do you get all that said in half an hour? Before he starts, I would ask all the speakers from this morning to stick around for the break because of the time problems we're having, that I haven't been able to allow for question period, but maybe you'll be able to nab the speakers during the break. So Terry, over to you.
Good morning. First thing I want to do is I'd like to acknowledge some assistance I had with the paper. These sorts of papers require help at times, and I've had a tremendous amount of help from our articling student who happens to be here today, Kim Putman. Kim, would you just stand up, please? Kim was very, very helpful in research and footnotes, and appreciative of it. What I'm going to try to do today is give you a bit of a flavor of what's contained in the paper. Obviously, as Elena said, I can't get through it in 30 minutes, but I'm going to try to give you a bit of a summary. It's unlikely that you're going to go and read through all of it, but I've tried to set out in the index a bit of a summary for you of the topic so it's easy to refer to. So I'm going to talk on some of the issues in it. You can either look at the index at the beginning of it, or you can look at the paper itself, and I'll refer to the particular page numbers that are referred to in it. The first thing I want to say is that the area of fundraising is extremely important to charities. I mean, to me, it's a statement of the obvious. It's the fuel which provides the charities with the ability to operate. But just like with any fuel, it's combustible, and therefore things can go wrong with it. Generally speaking, most charities consider themselves to be exempt from any liability. They often think that because of their altruistic work that they do, that somehow the courts and lawyers will deal with them differently than a business will be dealt with or trustees under an estate. And that's not the case. In fact, I would suggest to you that the greatest risk that there is to charities comes from this area of the bar in dealing with estates, because it's the beneficiaries of an estate who do not get the gift from mom and dad that they expected to get, because it's been given to a charity, that are apt to look at ways of trying to get the gift defeated. And therefore, there's sort of two hats that you can look at. One is from the standpoint of assisting charities, trying to keep them out of trouble, and then from the standpoint of acting for estates, of looking at ways, we have to, as lawyers, looking at ways of challenging the gifts that have been given. It's an interesting area dealing with in fundraising. It's a culture unto itself. I've given you some reference in the materials to nomenclature such as prospect research. That means fundraising. Or taking the verb to ask and turning it into a noun called the ask, whatever that means. Fundraising is big business. University of Toronto has a budget of $6 million. It apparently has 40 people on staff dealing with fundraising. The charities cannot operate without effective fundraising. There are organizations in place that are assisting fundraisers, and I think doing a very good job with it. But I think it's incumbent upon lawyers who deal with charities either on a more regular basis or because they're called in on occasion to be aware of the risks that are there so that you can point them out to the charitable client. That's the purpose of the paper. It's a bit of a heads up. You can't deal with everything that are liability risks, but you can point out a few areas for them. A lot of what I've set out in the paper is based on my own experience and my practice, as well as areas of interest. So it's very selective. It's not intended to be a comprehensive discussion of all areas of legal risk in fundraising. What I've set out for you is on page 3 is some of the areas of what I refer to as a new approach to fundraising, and it's based on the following. Charities need to raise monies. They don't always have the luxury of being able to thoroughly evaluate the risks. That's where the lawyer comes in. But in addition to there being inherent risks, now the public is starting to call for accountability. Some of you may be aware of the Broadbent report on accountability that came out earlier this year. And in it, there is a demand by the public for accountability from charities. And so in the past, charities have been able to do their work and their fundraising without much review. That's changing. That is now becoming very much a new area of demand and accountability. One of the other things that is important to this area is a recognition that directors of charities, I'm sure some of you are directors of charities here, have a fiduciary obligation to ensure that you're protecting the charitable assets that you're entrusted with. And that means that the fundraising programs that the charity is undertaking requires your review. Most boards of directors will be interested in the end result. Have you made enough monies from the particular program? But the law requires that the directors be accountable for any losses that occur through a fundraising program. And there are losses that do occur. As a result, there needs to be a communication between the management, the fundraisers, and the board of directors to highlight the areas of risk so that the board is aware of the risks that they're faced and that they can properly manage those risks on behalf of the charity. I set out for you on page 10 of the paper a section that deals with the danger of the follow the leader syndrome. Often charities will duplicate what other charities are doing without thinking. Because charity A does it, that means that we can do it. And they'll often simply copy type out the materials. You have to stop and you have to ask questions. And a good example of what can go wrong can be seen by looking south of the border. And I've set out an appendix for you at the back of the paper, an article I wrote a few years ago dealing with the New Era Foundation. That was a $250 million tax or charity fraud that occurred because one large charity after another charity got involved with the program. It basically was a Ponzi scheme where New Era Foundation promised to double the monies, the investments of charities within 6 months. So as monies came in, monies were being paid out. The word got out that this was a surefire investment for charities, and a number of charities lost a great deal of money through the process. That particular fundraising scam was found because there was an accountant within a charity that started to ask questions. And I mention it to you because as lawyers, we need to encourage the management, the fundraisers within the organizations that we advise to look, to ask questions and not to be afraid. Often there's a fear mentality within charitable organizations that it's not okay to question things. And I think it's incumbent upon us as lawyers to say it is okay. You need to do that. I set out in the paper on page 10 dealing with some fundamental considerations involved with fundraising. And I'll just mention a couple of them to you. First of all, fundraising is not an end in itself. It's simply a means to an end. But you have to make sure that the objects contained within the letters patent and the other constitutional documents provide that power. The fundraising that's done must be for a charitable purpose that is authorized by the charitable objects contained within the letters patent or within the special act of your charity. If not, it's ultra vires. And so you may have liability in having the board authorize a particular program for a purpose that's not contemplated by the charitable objects. Set out on page 15 a few comments about donors' rights and remedies. This is important because if there's going to be an exposure to liability faced by a charity and its board, it's going to come probably from the donors themselves. Three different areas. You can have liability because of misrepresentation, dealing with the tax benefits to be had and the gift to be made. And as I mentioned later in the paper, there is a proposed amendment to the Income Tax Act that will have civil penalties upon those that advise on tax matters if they do so without a proper assurance. There is a culpable test that now applies. Secondly, if there are restrictions that donors have applied to the gift, they must be complied with, failure of which there is a breach of trust. So there's an exposure to donor in that regard, and also to from the beneficiaries of an estate if a donor restriction is not complied with. Finally, in relation to sponsorship, there can be an exposure that charities have from donors if there's a detrimental reliance placed on the charity's endorsement of a particular product. We're seeing more of that through sponsorship arrangements. Under the Charities Accounting Act in Ontario, there are some statutory rights that donors have, and I've set that out at page 19 of the paper. And those statutory rights are fairly comprehensive, much more so than other jurisdictions in Canada. There's the right to call for a public inquiry. There's a right to require an investigation into breach of trust. There's a right to call for a court-ordered audit of a charity. All sorts of techniques are available for a donor and legal counsel that may want to challenge what a charity has done. In addition, if you contact the Charities Division of Revenue Canada, now known as Custom and Revenue Canada Agency as of November the 1st, you can have them become interested and conduct an audit on their own initiative into a charity. So there's a mechanism for calling a charity to account through the Revenue Canada's jurisdiction. I set out at page 27 some liability issues involved in fundraising through testamentary gifts. There are still a number of charities that are involved in actively giving estate planning advice to donors as part of their service to the donor and in the hope of getting a gift from that particular donor. That raises questions of undue influence and ability of the beneficiaries to set aside the gift. And I've set out in the paper some do's and don'ts in relation to potential for undue influence, such as preparing the will. There's still some charities that do it. Acting as an attorney under a power of attorney, acting as an estate trustee, paying for the legal cost of having a will prepared or a power of attorney, offering to store a will at the head office for the charity. All of that is consistent, or at least maybe some evidence that can be put forward of undue influence by the fundraiser upon the testator. I set out at page 32 a couple of comments about situations where a charity is asked to forgive or not to take a gift under an estate because the beneficiaries of an estate are in financial need. And the case law that's referred to there makes it clear that there is no authority for a charity on its own to forgive or not take a gift, voluntarily renounce a gift. It has to be done by a court. It comes up frequently, and you may be contacted and asked about that. Page 32, I deal with donor-restricted charitable gifts, and there is some materials referred to that I've prepared on this topic on another occasion, but what I wanted to mention to you today, and I briefly set out in the paper, or briefly summarized in the paper, is what can you do to avoid legal liability involving donor-restricted charitable gifts. In a nutshell, a donor-restricted gift is where the donor imposes terms, conditions, restrictions that must be complied with. Failure to do so is a breach of trust. That can expose the directors to personal liability. There are many situations where a charity will not understand the importance of complying with the terms of the restrictions. They'll have an endowment fund which they'll borrow from. They'll have an endowment fund which they'll spend. They'll have restrictions to use it for a building fund, but they're not going to build, and therefore they use it for another purpose. They're not aware of the need to apply to the court for a cypre order. And what I've set out is some suggestions that you can follow in assisting a charity to stay clear of situations that may involve a breach of trust. For instance, when an estate gift comes in, see if it's a donor-restricted charitable gift. Look at it. Look at the wording contained in the will. And if it is, then they have to manage that as almost like a charity within a charity and have it properly accounted for and ensure, of course, that they comply with the terms of the gift. If they can't comply with the terms because they're impossible or impractical, then they can apply for a cypre court order. On page 42, I set out a couple of comments concerning preventative steps that can be taken to reduce liability when there's fundraising for restricted gifts, such as a public fundraising campaign for a building project. There may be a surplus that is received beyond the cost of the building project. What do you do with the surplus? Very difficult on a cypre court application, but if you have in your materials a statement, the fundraising materials, stating that any surplus will be used for the general charitable purpose of the charity, then you basically have authority for a gift over beyond the particular building project. When you're structuring a will and you set up an endowment, a testamentary endowment, to make sure that there's a built-in cypre provision contained in it to provide the authority to vary the terms. On page 43, I go over some of the techniques that are used in fundraising that can be problematic. First of all, dealing with gifts of business interest on page 43. In Ontario, a gift of a business interest beyond 10% of the business is prohibited by the Charitable Gift Act. You have to sell that interest within a period of 7 years. It's not always understood. The proceeds from the sale have to be invested in accordance with the investment power under the Insurance Act. And again, that's not always understood. Dealing with gifts of real estate, we have under the Charities Accounting Act a prohibition in holding land for anything other than the charitable purpose of the charity for more than 7 years. Otherwise, the public guardian trustee can vest the property in their name, which basically means receiving a gift for investment purposes or for leasing is not an option in Ontario. It may be an option in other provinces. It's not in Ontario, and the public guardian trustee have made that very clear in the materials that they've put out. Self-insured gift annuities on page 48, something that I comment upon. It's an interesting area. There are there are a number of large religious denominations that issue self-insured annuities. Self-insured is where the charity itself becomes the insurer for the payments under the annuity, as opposed to using an insurance company. The question there is there the corporate authority to do so? Some of the larger religious denominations have that authority. The second question is there a requirement to become licensed under the Insurance Act? in the particular province. The material reviews that. The position of the PGT here in Ontario is that you have to be licensed under the Insurance Act, whether or not you have the corporate power. We've done some communications with BC, and we set out at Appendix 4 a copy of a letter from the Superintendent of Insurance in BC that basically says the same thing. So if you have a charity that's involved in issuing annuities, self-insured annuities, even if they have the corporate power under their incorporating legislation, they may still have to comply with insurance legislation in the particular province that they're selling in. I've made reference in the materials to the U.S. experience. There was a class action back in 1995 involving a number of Lutheran church charities, and it was a huge class action based upon price fixing, allegations of price fixing, because the amount of the annuity payout was less than market. And it was brought because some beneficiaries of estates were unhappy that there was the monies from the annuity were going to the charity as opposed to themselves. That resulted in there having to be legislation passed in Congress to protect charities south of the border. I mention that because just because here in Ontario and Canada we've not had challenges to the issuance of self-insured annuities does not mean that it may not happen. It's happened south of the border, and it could very well happen here in Canada as well. Generally speaking, if a charity is interested in annuities, the best thing to do is work with an insurance company with a reinsured annuity product. Over on page 56, I review the issues of soliciting investments from the public. This was more common when charities were in financial difficulties at the end of the recession back in the early 1990s. They couldn't get enough monies from fundraising directly. They couldn't get monies from the banks, so they would start to issue bonds and certificates and mortgage-backed certificates and debentures and so forth, trying to raise monies to keep afloat. Some of those securities got into difficulties, were not paid out completely, and as a result, questions came up of whether or not they should have been issued in the first place and whether or not directors were liable for them. I set out in the material some examples of those types of securities, and also made reference to the Securities Act with a notation that the exemption under the Security Act is predicated on the fact that there's no commission or remuneration payable on the sale of those securities. So if you've got a fundraiser that's involved in selling those securities, even on a salary base or based upon a commission or something similar to that, that may take away the exemption under the Securities Act that currently applies to charities. In addition to that, there can be, again, where an investment goes sour, allegations made against the charity and the board for misrepresentation. Misrepresentation because the investor did not know the full extent of the risk, because the investor thought that the type of security, i.e. a bond or a, quote, debenture, quote, suggested security, such as a mortgage to back up the security that was not there. So I think that there's potential for liability exposure for the directors that become involved in issuance of securities by charities. Over on page 64, dealing with investment issues and fundraising, I refer you to a very excellent paper by Tim Youdan that he did at a seminar last year for a more complete discussion, but a couple of things have come up in the last couple of months. As you're aware, the delegation issue is a factor, and for charities that's a very serious problem. Those large charities that have to use a discretionary fund manager are concerned that Bill 25 amending the Trustee Act has taken that away. There's been a lot of debate about it. At page 67 of the paper, I make reference to a quotation from a letter from the Attorney General of Ontario to the Canadian Bankers Association, and I won't read it, but it basically says that when they did Bill 25, they intentionally did not give the power to delegate because it involved a number of policy considerations. And notwithstanding that charities are trying to deal with it in a reasonable basis, and I've made reference to a letter from the Public Guardian Trustee of Ontario about a reasonable interpretation, it still is necessary to have the government reconsider this matter, and the Canadian Bar Association is involved through our charity section in lobbying the government to have a change made so that there will be the power to delegate. The other matter dealing with investments set out for you on page 65 is that there can be various investment powers that apply to charitable funds, not just one. You have to look at Giletta's patent, you have to look at Bill 25. If you've got an endowment from an estate, you have to look at the investment powers in the estate document. If there's an inter vivos endowment, then you have to look at the terms that are contained within it. So it's important to track the different investment powers that are in place for a charity. Over on page 68, I make reference to a new program that's in place involving pooled investment funds, where one charity will pool the investments on behalf of a number of other charities to get a better return and keep administration costs down. That is an area that should be looked at very carefully. What I suggest in the paper is that there are issues involving the Loan and Trust Corporations Act that should be looked at. There are issues involving commingling of restricted funds by one charity where there may not be the authority to do so. Certainly there isn't the authority at common law. There may not be the corporate authority by the recipient charity to do that. And the new regulations coming out under the Charities Accounting Act are not expected to provide the authority to be able to commingle funds of different charities. Commingle their own funds, yes, but commingle funds of other charities, not likely. Page 72, go into a brief discussion about matters of sponsorship. This is going to be a major area of income for charities in the future. Sponsorships such as the Canadian Olympic Association, Timex is the proud sponsor of the Canadian Olympics, or situations where the name of a charity is associated with a product. I give an example of Save the Children are involved in having their names put on various products that are going to be sold. This is happening a lot down the States and will happen more here in Canada. In advising a charity, obviously there needs to be a carefully worded sponsorship agreement, but more importantly is the name of the charity and its logos are trademarks that need to be carefully protected, registered, and then properly licensed over to the user of it. Failure to do that can undermine the trademark itself. So it becomes easier for pirates to go out and attack the trademark of the charity. Very important to properly manage the intellectual property portfolio of the charity. Page 79, I talk about some issues dealing with retaining a professional fundraiser, and that leads into two pieces of legislation. One deals with the Alberta Charitable Fundraising Act. Any charities that are dealing in fundraising in Alberta, more than $25,000 a year, will have to comply with the act. I've given you a copy of it. It's a very detailed, comprehensive act. In addition, I've made reference on page 84 to the Federal Competitions Act. Bill C-20, March the 18th of this year, amended that act. Basically, fundraising is now considered to be a business under that act. And so that means in relation to telemarketing, you have to comply with the provisions contained within that act. Failure to do so is a criminal offense. And it also provides that directors and officers of the charity can be held personally liable for failure to comply with the telemarketing provisions. What's interesting is that the telemarketing is defined in fairly narrow terms. Just refers to telephone interaction, so it doesn't deal with the internet. But there's another provision contained within the Competitions Act that deals with false or misleading representation that's much broader and would apply to fundraising on the internet or door-to-door sales. And again, I point that out to you in the materials. You want to look through it very carefully because your charity, your board, your officers are going to be faced with new exposure to liability and criminal sanctions under the Competitions Act that has just come into effect this year. Two other things I want to mention is on page 92, dealing with the regulations to come out under the Charities Accounting Act. They're not yet available. So unfortunately, I can't discuss the details with you. But I pointed out two things. One is it's not anticipated there will be any authority to commingle funds of different charities together by one charity. Secondly, there is, it looks like it's a bit of an error. The regulations were supposed to authorize indemnification of directors. And we'll see once the regulations come out. But under Bill 25, amending the Corporations Act, what they said under Section 133 is that the authority to indemnify directors is taken away from charitable corporations. I think what they meant to say was it's taken away provided that, or unless you comply with the regulations under the Charities Accounting Act, but they didn't do that. So the matter is hopefully going to be corrected by the government, but at the present time, the statutory authority under the Corporations Act to indemnify directors and officers for charitable corporations is not there. That can cause concern both for your board and for the insurance that's in place, because a lot of the insurance is dependent upon the corporation having indemnified the director under the general liability provision. Finally, under dealing with some of the tax issues, and I've intentionally tried to stay away from the tax issues, they've been dealt with thoroughly by others, is on page 97, dealing with some selected examples of improper issuance of charitable receipts. Recent case that was decided October the 21st of Woolner involved taxpayers that had provided funds to a charitable or scholarship for means of getting monies over to pay the tuition fees of their children, and there was 100% receipts being issued. That was questioned by Revenue Canada. They were successful on appeal, and as a result, any of these programs where there's 100% receipts being issued for tuition fees of religious or private schools is not an option. Finally, at the very end of the paper, there's a reference to the gifts of vacation properties. A lot of you may be involved in fundraising dinners where there will be 2 weeks or 1 week at a condominium owned by a donor who's given that up. And the thought has been in the past that there was the ability for the charity to issue a receipt for the use of vacation property. As of April of this year, Revenue Canada has changed its position. They do not consider it to be a gift of property, and therefore no receipts can be issued by a charity for the use of vacation property. That, in a running snapshot, is an overview of the paper, and there's materials there for you for resource purposes later on. Thank you.
Thank you very much, Terry. That was extraordinary. I've just been flipping through the paper, and it's got a lot of very valuable information in it, and as well, Terry has been kind enough to provide us with copies of other papers that he has presented. Charity work is becoming much more important, and is probably a large part of the practice of a number of people, and as Terry said, also because of your own personal involvement in charities, it's good to have this information. We will take a 15-minute break, so if you could be back by 11:20, we have a very tight program, so I'd appreciate an early return. Thanks.